We'll get started. I expect most of you guys know George Murphy. If you don't, George Murphy is a long-time trial advocacy professor at UofH. My professor, I know, is many of our professors. He's a hell of a trial lawyer. And he's here to sort of do the second in our monthly hands-on CLE training. And he's going to be talking about cross-examination. I've given him about 4 different fact scenarios of trial cases we've got coming up, and he's going to go through each one. And then he's going to spend some time just talking about cross-examination more broadly, and then we'll get right into it. So, George Murphy.
Hey, all right, Mr. Murphy.
Yes.
You became a lawyer on May the 4th of 1990.
Yes.
And I bring that up because May the 4th, 2015 is coming up. It'll be your 25th anniversary.
I think the math says 25 years.
Something you're very proud of.
Yes.
So, back on May the 4th of 1990, you had your very first job as a lawyer.
Yes.
And your very first job as a lawyer was at the Harris County District Attorney's Office, right?
That's correct.
And you worked there for a few years.
Yes.
And you tried a little more than 30 cases while you were at the DA's office.
A little over 30, yes.
What that means is you did a little more than 30 voir dires.
Correct.
Did a little more than 30 final arguments.
Correct.
You cross-examined, direct examined many more than 30 witnesses.
Yes.
The area of the trial that you had the least experience in was cross-examination, right?
I would agree with that.
And that's because it's a function of what prosecutors do. Many times the state rests right behind. The defense rests right behind you, right?
Oftentimes that was the case.
So after you left the DA's office, you went to work at the Federal Public Defender.
Yes.
You worked there for 3 years.
Yes.
And there you tried 15 or so jury trials, correct?
Yes, 15.
And of course, now as you're a defense lawyer, you had a lot more experience cross-examining witnesses.
Crossed a lot more people as a defense attorney, yes.
So the answer is yes?
Yes.
So now, during this time, you also began teaching trial advocacy at the University of Houston Law School.
One of my graduate minutes, yes.
So you did, is that the answer yes?
Yes.
You taught law students direct examinations.
Yes.
You taught them cross-examinations.
I did.
You felt good about your trial skills.
I really did.
Then you went down and roughly the year 1999 had a trial in Galveston County.
Yes.
You represented a young man.
I do remember that, yes.
And there was another young man who was also accused.
It was co-defendant, yes.
And that person was represented by another lawyer.
Yes.
And that lawyer was somebody who's very experienced.
Yes.
Somebody looked up to.
Yeah.
Been around a while.
A long time.
And he sat with you during this trial. He represented his own client.
Yeah, that's correct.
And there came a moment in the trial where you did a cross-examination.
I did.
Is that true?
Yes, that was true.
Now, you knew how critical this cross-examination was, didn't you?
I know it was very critical, yes.
You knew that it was critical to the verdict that this jury would reach.
Yes.
You knew it was critical to your own client,
Yes.
and you knew it was critical to the other client too, right?
Absolutely.
And as you stood up to do this cross-examination, you had all the trial experience of the DA's office.
Yeah.
You had all the trial experience of the Federal Public Defender's office.
I did.
And you conducted this cross-examination with a certain degree of confidence.
I was confident that day, yes.
When the cross-examination was over, you went back to counsel table, correct?
Yes.
and you sat next to this lawyer who was very experienced.
Right next to him, yes.
This lawyer who you admired and looked up to.
I did.
And he had drawn a picture while you were conducting your cross-examination.
He did a picture, yes.
When you sat down, he pushed that picture over to you, didn't he?
He did.
And this picture depicted the quality of your cross-examination.
He did.
It was pretty accurate, wasn't it?
Looking back, I would say it's very accurate.
Yeah. Judge, I moved to, you authenticate this, huh, Judge? I moved to defense exhibit number 1. Can I show this to the jury, Judge? What we see here is the USS Murphy going straight down to the depths of the ocean, right?
That's true.
You have succeeded in not only convicting your client, but his too.
Yeah, we're both convicted.
All right. All right, that's it. That's the worst cross-examination I've ever done. I won't bore you with the details of it, but it was awful. The takeaway is that cross-examination is difficult, of course. I don't care how many times you do it. It's a learning process, and in my experience, there's only one way to become a good cross-examiner, and that's to do it. And it's difficult in our day and age to get a bunch of trials and do a bunch of cross-examinations, but it's the single best way to do it. Now, you can read about it, you can watch it on YouTube, some guy can come talk to you about it, but learning it and understanding it and doing it well only comes with practice. What I wanted you to hear with this little cross-examination was a couple of things. One is I want you to hear the cadence of cross. Good crosses have rhythm, and they have a cadence. They have a sense or a flow, all right? And it comes from knowing your story very well. It comes from the forensics of it, which we're going to talk about in a little bit. But I want you to just step back for a second and feel and sense the rhythm of that cross. The second thing is, and this is what I really want to visit with you about more than anything, and that is, I told you a story, right? What we get caught up in too much, I think, as cross-examiners, as trial lawyers, is we forget that what we're really doing is telling the story. And cross-examination is bits, and maybe it's your full story. Maybe it's one witness and you're going to tell your whole story. But often it's the bits and pieces of your story, but it is a story nonetheless. And I was able to tell you the story of a very embarrassing, awful time for me, worse for my client, through this guy, who was irrelevant in the whole process, right? So what I want to visit with you about is storytelling in cross. We're going to talk in a bit about how to do the forensics of a good cross, right? How to ask leading questions, the importance of it, and how to control witnesses. We're going to chat about that. But I want you to think at least for a bit about storytelling. Who here knows a bad storyteller? Who here knows a bad storyteller? You got to know a bad storyteller. By the way, that's one of the best board iron techniques you can have, right? When you ask a question and you get the silence from which you normally get, just raise your hand long enough and people ultimately feel sorry for you because you're the only one raising your hand and they'll say something. So, but do you know bad storytellers? What makes them a bad storyteller?
Inconsistent.
They tell stories that are
Inconsistent. Yeah, they'll tell stories that are inconsistent. They leave out details too.
right. What else makes a person a bad storyteller? In your mind?
Too long and confusing.
Long and confusing. Right. What else?
Give too much information.
Too much.
Too much
That's right.
information.
Too much information. What else? Anything else?
Dry.
Too dry. Not interesting. A little boring. What are some other examples of bad storytelling?
They go out of order.
Say again?
They go out of order.
Yeah, out of order, hard to follow. I play poker every Thursday night. It's a table, it's 10 or 12 guys, and at the poker table, there's a bunch going on. You know, I'm in a hand, he's not in a hand, he's getting a drink, he's already drunk. What about my cards? And it's that. And there's a guy who always tries to tell a story at the poker table. It's always too long, and by the end of it, he's the only one who's listening to his story. He's forgotten who his audience is. It's another typical issue with people who tell bad stories. All of those attributes that we talked about, do you think those apply to being a cross-examiner?
Yes.
Do you think if you are give too many details, too much packed in, can that impact how the jury reacts to your story? If you bounce around too much, you don't have a real logical flow, could that impact how the jury gets your story? All of those things are important. So what do you do? Does anybody here practice storytelling? Yeah. How?
How?
Yeah, when do you do
I
that?
teach Sunday school at my church,
Yeah.
and so I tell a lot of stories during the Sunday school lesson. Is one way I practice. Another way is I talk to my kids, and I teach. When I talk to them, I use allegory and story and explaining things to them, and so I practice it that way as well.
Right. You think it's more, you're having more success in your parenting and your teaching by using stories?
Yes.
You think that's true in trials?
Yes.
It's not easy. I mean, it's not easy to be a good storyteller. It's not always easy to find the story of our cases. You know, there are a lot of difficult cases that we all have. It's difficult to find the story. It's difficult to find the emotion. I understand that. But the best, to the best that you can, find the story and tell the story. I'll tell you one thing I always do. The phrase, once upon a time, when you say that phrase or you hear that phrase, you know it's storytelling, right? Before I start a trial, before I do particularly my opening statement, in my own mind, I will say to myself, once upon a time. I can't tell you how much it helps me. It helps me when I'm preparing my trial, but it also helps me when I'm actually in trial. Please come in. So practice your storytelling. Who here tells a good story? Anybody say they're a good storyteller? We got one.
Eric always tells me that.
Who's a good joke teller?
Damn.
Who tells a good joke?
He tells good punchlines.
I gotta find this joke. Hold on. Can any of y'all tell a joke this well, all right? Are you ready? Okay, I'm gonna show you. Oh, wait a minute, I don't have the internet. God, you ever seen the penguins telling the monkeys telling the penguin joke? Okay, YouTube that. Everybody, you put that in your notes. Monkeys telling the penguin joke. It's a little blue anyway, so maybe I shouldn't do it, you know, but you gotta get to where you can tell a joke as good as these monkeys. If you do that, you're good. So what makes a good story for cross-examination? What are the keys to good storytelling? Keys to good storytelling, we talked about. Those are the tactics you need to tell a good story. But for your story, your cross, to be important, to be effective, it has to be two things. It has to be meaningful, and it has to be memorable. And how do you do? What does it mean to be meaningful? It has to relate to your defense. Have you ever seen people do cross-examinations about stuff that doesn't even matter? Right? Look, hey, guilty as charged. I've done it because I was afraid not. I was afraid to do nothing. What I was afraid to do was short cross-examination. I was afraid that I'm not going to look like I'm a big-time lawyer if I'm not up there cross-examining somebody. And if you're doing that, you're not doing a meaningful cross-examination, which means you're going nowhere. The cross has to push the ball forward of your defense. It has to relate to your defense. And it should the best you can, that you know that you're gonna be arguing, that you know are gonna be in your, jury charge. Great way to do that is to carry those themes from voir dire and always stated into your cross, that you know you'll be arguing, that you know are gonna appear in your jury charge, okay? So it has to be meaningful, which means it has to be relevant to your defense. And do not be afraid to have zero cross if you can't do a meaningful one. And it has to be memorable. There are lots of little tricks and things to do in order for it to be memorable. We talked about some of the things that you shouldn't do. Some of the things I think that are very important to do, and that is, best you can use visual aids. Write things down, use exhibits. What is the one thing you're probably going to remember from the little cross-examination I did? Right? You're probably going to remember that. Why? Because it's a visual thing. The more that you can use visual aids and demonstrative aids in your cross-examination, the more memorable the cross-examination is going to be. Use flip chart. Who knows what a flip chart is? Wow. I thought that was so old school anymore. PowerPoints, flip charts. Bring it to life. Be demonstrative yourself if you can. If you and the witness can do something together, do it. The more that the jury sees, the more that they'll remember. Of course, use your voice. I know lawyers who are on 10 all the time. Everything they do is on 10. You know, the volume is cranked up, or they're on one or the other. Obviously, modulate and use your voice. And here's something I think is important, and you may not. If it makes you feel uncomfortable, don't. I think it's important to look at the jury. I think it's critically important to look at the jury. And I don't mean just looking at them. I mean having meaningful communication with a juror while I'm doing my cross-examination. I want to I can't help it, I have to, because I want them to pay attention so much. I want them to believe what I'm saying so much. It's as if I am trying, literally almost physically trying to grab them and say, please look, I'm right. But I think it will help you do this too. I think it'll help it to be more memorable. But I also think that will help you remember who you're communicating with when you're doing your cross-examination. Often, cross-examiners think, and they fall into the pattern of communicating with a witness. You're not doing that. That's nothing to do with cross-examination. What the witness does or says is meaningless. I'm not communicating with that person. I'm communicating with my audience. And what person is communicating with somebody else is not looking at them. It's rude. I don't think I do it because I think it's rude. I think I do it because I just cannot help myself. I want to be believed so bad that I'm doing everything I can with my eyesight to grab them and help them. When we do crosses in a little bit, we're going to do a few. I want to practice that. I want to practice you cross-examining. We've got our witness here without looking at him and looking at the rest of us. Loop your answers. Obviously, repeat things that are important to you. The more you repeat them, the more they're likely to be remembered. You got to be careful, of course. You don't want to be the guy who's pounding, on the same point all the time. But you've also got to know that those 12 people up there, maybe 2 or 3 of them aren't paying attention. Maybe 10 or 11 of them aren't paying attention. So they may miss it the first time, but they're going to get it the second time. And you all know what looping is, of course. But take that good part of that answer, begin your question with it, and then ask your next question. So loop, repeat. Of course, using only the necessary details, I think, is critically important too. We live, and be brief. Be brief. I remember when I first started at the DA's office. Richard Haynes was still big time, and he would still try cases, and we would go to the courthouse and we would watch him. his cross-examinations were the most boring, drawn-out things you can imagine.
I used to read his transcripts.
You know, and of course, I'm there to see Richard. Hey, you know, and to just put somebody in a headlock and it never seemed to happen. They went on, they were interminable and boring to me. We just live in a different time. We live in a time, we live in a remote control society. And if you're not clicking with that juror quickly, then they're not likely to remember you and to remember what you're saying. So be brief, get to the point, repeat it, and then move on. Now, those are the things about storytelling. I would say practice your storytelling, practice your joke telling, and begin to think about cross-examination more as a story than as a forensic evidence. But having said that, you gotta be, you gotta know how to control the witness, which is what it really all comes down to, right? So let's talk a little bit about that. How many, I don't know what your trial experiences are. Do you have, see many familiar faces, and I know that you've tried a million cases. If I said for you to lead a witness, everybody knows what that is, to lead a witness. I'm assuming you have a significant amount of trial experience. Am I right about that? Or is it varying degrees of trial experience? How many here have tried less than 20 cases? More than 100. Well, here's what I would tell you, the three most important things about doing a qualified cross-examination is prepare, organize, and then ultimately, of course, control. You have to prepare, you have to organize, and you have to control the witness. How do you prepare? Let me tell you how I do it. Of course, I know every single part of the offense report and every single part of the government's case and every single part of my own, all right? The first thing you have to do, obviously, is be intimately familiar with the file. You have to then have a very clear and concise theory of the defense, okay? You have to know what the defense is, and you have to be able to break it down to a one-sentence defense, case of self-defense. It didn't happen. My guy was, what the secrets would say, trout fishing in Quebec. I mean, whatever it is, you got to know exactly what the defense is. Then you can't prepare across until you do. I tell you what I do. I write my topic areas down. Anybody ever read the cross-examination book by Posner? He talks about the chapter method of cross-examination, and that's what I tend to use. It's very important to look at it. Okay. What generally he does is he takes he breaks the cross into chapters, into separate headings or points. So the title of the chapter might be Officer's Decision Not to Read Miranda. Okay? And then under that chapter, he will have his subpoints that all together lead up to improve the chapter heading. Now, here's where I think a lot of young lawyers make mistakes, is that they tend to try to prove in their cross-examination or get the witness to agree that the chapter heading is right, whatever it happens to be. You know, she couldn't see the offense. She couldn't see the suspect. So one subtopic might be light, and then you'll have all the areas you're going to bring up with light. The distance, the eyewitnesses' vision problems, whatever it is. But what I encourage you to not do in your cross-examinations, and I don't either, I'm not there yet, is not ask that big summation question. If you sense that you're about to start a question with the word "so," I want you to double check yourself. So, you really couldn't see that, well, no, I really could. We heard this story the other day. The lawyer is a prosecutor cross-examining an eyewitness for the defense. And went through all of this stuff about how far it was, and, how the lighting was, and how dim it was, and how excited and emotional and everything it was. And then asked, you didn't have binoculars, did you? And the witness said,
Yep.
yeah, actually I did. It happens, we see it often, it's the one question too many. What do you do with that chapter? Who do you tell that chapter heading to? The jury in your argument, right? So it's 1 + 1 + 1 + 1. Forget what comes after the equal sign, okay? Argue that. One day, when Craig Washington, who I think is just such an extraordinary cross-examiner. Do y'all know Craig? Wow. He's amazing. He's got the presence of voice, the whole deal. When we all are him, then we can do the equals and then what comes after that. Right now, let's keep it simple, and we'll keep from gutting ourselves in trials. 1 + 1 + 1 + 1. And then we argue the answer, okay? What I do is when I'm preparing, I will have a file for every witness. Do you? Do you have a file for each of the government's witnesses? Do you? Okay. Have a file for each of the government's witnesses. And in that file, you put that part of the